Can New York State Department of Health refuse to comply with a FOIL request based upon internal regulations? To find out, you have to read Matter of Reclaim the Records versus Department of Health, but it's 49 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases, and I try to do it in 5 minutes or less. This is the episode on the case of Matter of Reclaim the Records versus New York State's Department of Health. The citation for this case is 2025, New York Slip Opinion 03102, published by the New York Court of Appeals on May 22nd of 2025. The issue in this case is whether the New York State Department of Health wrongfully denied a Freedom of Information request based upon their internal policy of not providing records of people who died within the last 50 years, amongst other issues in this appeal. To understand and appreciate the context of this case, what's helpful to know is that in New York State, we have a Freedom of Information law, which is found in Public Officers Law, sections 84 to 90. And basically, there's a presumption in New York State that the work of the government is for the public, and public has the right to request documentation for any reason or no reason of what the government's doing on their behalf. As long as the request reasonably describes the material, and the material can be obtained without undue hardship, and as long as it's not doesn't request material that's an unwarranted invasion of personal privacy, that material should be gathered by the government and returned to the person making the FOIL request. They can be charged for that request for the efforts undertaken to get the material. And in New York State, the other thing you have to know is that Public Health Law 4100 requires the Department of Health in New York State to prepare for all areas of New York State outside of New York City, to prepare and maintain an index of all births and deaths in New York State. And it's been doing that work for over 100 years. And you should know that the Department of Health passed an internal policy regulation to carry out its work, which can be found at 10 NYS 35.5 C3D, that basically creates a 50-year waiting period. It says that we are exempting from disclosure all materials related to deaths that occurred in the last 50 years. And so as time moves on, that 50-year waiting period follows along with it. Except for it's waived, that policy is waived for direct descendants of the person whose record is requested. So if your parents died, you can request the material and they're not going to impose a 50-year waiting period on you. But as to everybody else, if you're not a descendant of the person whose record you're requesting, they will deny your request for materials for people who died in the last 50 years under that provision that they created. Now, the Department of Health, in their index, they actually have an online index that contains all materials from 1957 to 1972. That contains last name, first name, middle initial, date of death, age of death, gender, residence code, and state file number. But that's not all the material that the Department of Health has. They have other materials that are not included on that index, including location of interment, whether they're an anatomical donor, whether they're like an organ donor, cause of death, medical history, things like that are not included on the online registry, nor is stuff included on the online registry that's pre-1957 or post-1957 or post-1972 because of that 50-year window. That's based upon the facts of this case. At this point, it would be 1975, right? Because we're in 2025. Okay. So what are the facts in this case? The facts are that Matter of Reclaim the Records. Reclaim the Records is a not-for-profit organization. It's national. I think it's located in California. But what they do is they make FOIL requests to all these different departments of health all over the country and try to gather genealogical records and make it available to the public for free. So instead of you having to go to New York State offices and pay a $10 fee or whatever the fee is to get a record, they would have it. Reclaim the Records goal is to have all the information for everyone's genealogical history and avail all the materials that the state would have with respect to births and deaths online available for anybody who wants it. So they filed a FOIL request with the Department of Health to gather all the materials that they have on everyone who died, basically always, for as long as they have the records. And the Department of Health denied that FOIL request for a couple of reasons. Said with respect to everyone after 1972, it violates our 50-year rule. We're not going to give you that rec. We're not going to give you those records. They're excluded based upon our policy. And with respect to the stuff that we're not, that we with respect to location of interment, anatomical gifts, all these protected policies, these areas that are private, allegedly, according to the Department of Health, we're not going to give it to you because they're private and it would be an unwarranted invasion of personal privacy. So that's the major arguments they made. Ultimately, the New York State, and then ultimately Ancestry.com filed the same exact request after Reclaim the Records and got a much better answer, which is why Reclaim the Records then filed this lawsuit under Article 78, saying that they're not doing what they're supposed to be doing. It goes all the way to the Court of Appeals, and here the Court of Appeals holds. They say that the Department of Health must, under FOIL, under that Freedom of Information Law, release the same basic identifiers that had already posted online from 57 to 72 for everybody from 72 all the way to 2017, which is when this litigation went to. They say the 50-year rule, that 50-year exclusion that the Department of Health imposed themselves is not a valid reason to deny FOIL requests. They say the FOIL is a law, and this 50-year rule is an internal regulation, and an internal regulation does not trump a law. The law says you got to give it, so you got to give it. And the other thing they say, the Court of Appeals holds here, is that the categories that would be an unwarranted violation of personal privacy may be restricted and not given. They're too sensitive. Those would be medical history, cause of death, location of interment, burial cremation details, anatomical gift status. These are categorically exempt as an unwarranted invasion of personal privacy. And as to any other materials, they remit it back down for an in-camera review by the Supreme Court as to whether materials should be exempt or not exempt. But that's essentially the holding of Reclaim the Records versus New York State Department of Health. This is the most extensive examination of a FOIL issue since 2005, which involved 9/11, release of 9/11 phone calls on 9/11. And that's the case of matter Reclaim the Records versus New York State Department of Health. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.